A very good day to you all. Welcome to the Wall Street Blockchain Alliance's Call the Lawyers podcast number 7. My name is Ron Quaranta, chair of the Wall Street Blockchain Alliance. Before we begin, some preliminary statements. This is not legal or investment advice, and our collective views are only the views of ourselves and not our respective organizations. I'm very privileged today to have an old friend, Mr. Lewis Cohen, on the podcast. Lewis, how are you, sir?
I'm doing great, Ron. Thanks for having me on.
Thank you for being here. You and I know each other for several years. We've been in the space for a long time. I would love, for the audience's sake, tell us about your progression. How did you get into this space? How did DLX law happen, and what was that kind of background that's really important?
Yeah, no, thank you, Ron. And just a quick shout out to all the amazing work that you and the whole WSBA team do. It's really a credit to our community. And I think folks listening to this, if you're not, members or not involved, should really get involved because it's just a great organization. My own background, very briefly, is that I was a partner at a couple of very large law firms for many years doing capital markets and structured finance work. And in 2015, having kind of gotten over the hump of the great financial crisis and being very involved in that, I started kind of looking around for what's next and had read a bit about blockchain in the capital markets and took the idea to an entity at the time called the Structured Finance Industry Group. It's now known as the Structured Finance Association, SFA. And I was on the board and said, I think this idea of blockchain, could be important in helping the financial sector sort of get past some of the challenges that arose during the financial crisis, particularly around securitization. And the board and the executive chair really liked the idea. And I spent, the better part of a year evangelizing about blockchain and all of its potential benefits. And that really took me down the rabbit hole. I founded the blockchain group at the firm I was at the time, and really got very involved. But it also became clear to me that blockchain was much more than fintech, and even much more than what a traditional law firm is really set up to do. Many of the clients I wanted to work with were small. There were startups. There was a lot of things that are just not done the way large law firms work. And so when I was fortunate enough to meet my co-founder, Angela Wilson, who was the general counsel at a major enterprise blockchain company, Digital Asset Holding, we kind of put our heads together and said, there's a place in the market for lawyers who are quite experienced, have a lot of big firm know-how and kind of understanding of how financial markets work, but also really love the technology and understand it and want to kind of geek out with our clients about it and are ready to take on a range of matters. I've always felt, Ron, that one of the most important things for a lawyer is to, as I like to say, get your toes in the mud. It's very hard to advise at a high level if you're not, actually working day to day with the kinds of problems that clients are facing. And in many large law firms, it's simply not practical. They're very, rigid targets for profitability and also for what clients can and cannot be taken on. And it's difficult for large law firms to take on small clients and kind of get your toes in the mud. So part of our thinking with DLX Law, which we founded just about 3 years ago in May of 2018, was to allow us to do that.
It's interesting, Lewis, as you say that, and we're privileged to have large and small law firms that are members of the WSBA and the legal working group. And I would argue that the pace of innovation in this space has been so fast that, and most of them have a blockchain practice in some way, shape, or form, which is wonderful. It requires a nimble firm like a DLX, for example, to really address those changes. Are you seeing, and I know we didn't really address this in the prep, but are you seeing that kind of migration or growth of smaller, very focused practice firms? What's that look like, the legal landscape, in your opinion?
Sure, it's a great point. And I want to just give credit where due. There are a number of some of our largest law firms that have fantastic teams and really do understand what they're doing. It's take a little while for them to get there, but it's not to say that there aren't large law firms that at this point have done that. But I do agree with you. Overall, smaller firms that can be a bit more nimble, that can be adaptive, that can take on smaller startup clients that are just not efficient for larger law firms, do have somewhat of an advantage in this space. And I think when you look back, Ron, what I remember well when I first broached the idea with the global managing partner of the firm I was at the time of a blockchain group, the response was block what?
Yeah.
What? And in give or take 5 years, we've gone from block what to I think it would be difficult or impossible to find an AmLaw 100 firm that doesn't have a blockchain group or team. And that's a remarkable transition in an incredibly short amount of time for almost everyone to recognize that this technology gives rise to important work. So I think large firms and small firms are diving in, but I do think in this space, smaller, more nimble, and more targeted firms have some distinct advantages.
Right. And I think, you and I have been in the space, as we talked about, for many years. You and I, we've seen kind of Bitcoin when it was at 1,200 and people were saying, oh my God, this is a bubble and it's ridiculous. We went through the ICO phase. We've gone through STOs broadly. And I won't even start on NFTs because that's its own podcast. How has your perspective changed? You were kind of a believer, quote unquote, at least from the technology perspective and the crypto assets perspectives early on. How has your perspective evolved? Is it proceeding the way you imagined? In my mind, things are branching off in ways we didn't anticipate, which is critical to law and legislation and global financial markets. What's your view on how it's progressed?
That's a great question, Ron. When, for lack of a better term, ICOs, were getting going, there was a lot I was very intrigued about with them. And the idea that you can own, interest in a protocol through a token rather than owning a business and, sort of being part of a peer-to-peer marketplace was extremely enticing. I'm a big fan of the economist Ronald Coase, who had almost predicted this back in the 1930s. And so that idea was extremely intriguing to me. As things played out, there were a lot of defects in the way the ICO model worked, and that was lessons learned for a lot of folks. Primarily, I mean, certainly there were very valid securities law issues, and I always had a lot of respect for that. But even more than the securities law issues, the problem of raising in one big gulp a large amount of capital that a founding team then had to deploy to complete the development of a network and the idea really did not pan out very well in almost every case. The problem is that the incentive structure. People don't work very well when they have all their founding, all their funding up front. And so we saw a lot of projects. Firstly, there were a lot of just bad projects, bad ideas that got funded. And even for the better projects, one of the problems was if you're funded with 3 to 4 years of runway, your enthusiasm for delivering solutions is limited. Also, for all the negativity around venture capital firms and their roles in technology growth, they do provide, a check and balance to founding teams that have to meet targets and have to answer to a board and have to do a lot of things. When that's taken away, you didn't really have an equivalent, a diversified group of token holders who don't have any rights and of necessity don't have any rights, don't really provide the same foil. And so one of the lessons for me was that although I still very much believe in the possibility of using blockchain technology to create really self-operating marketplaces where token ownership, it equates to ownership of the market. There is no company. We have to recognize that the original capital raising methodology of ICOs really did not play out the way anybody had hoped to in 2015, 16, 17, 18.
It's interesting. It reminds me of a conversation I had with a venture capital colleague in the ICO craze. And I said, well, aren't you concerned this is going to disrupt venture capital? You guys are going to become dinosaurs. And he said, let me understand, all of this value gets dropped on these young technologists early on, and you think they're going to deliver something. We're not going anywhere. Good luck, was his perspective. And he had a point, because there were no guardrails around actually delivering. So from that perspective as well, I want to address capital raising a little bit, because I think it's parenthetical to this, but critical. I don't think we'd argue that capital raising is easy, relatively speaking. So there are benefits, and I'm going where you probably suspect, which is in the world of DeFi and kind of changing how capital is raised. And we could probably have very tortured conversations about SPACs at some point. But you do see, I assume, the benefits of crypto assets, DeFi, and blockchain from the capital raising perspective, but needing that kind of regulatory overlay that keeps investors safe. Is that the perspective of regulators as well? and or is it totally still blockchain, crypto, we're going to regulate the crap out of this and make it go away? And I know where you sit, but I'd love for the audience to hear that perspective.
Sure. I mean, it's hard, and I know you don't intend to do this, Ron, to put all regulators into sort of one bucket, as if there was, some common way of thinking. In the regulatory community, there's a wide, divergence, all the way from, SEC Commissioner Hester Peirce, who's of course been a strong advocate for innovation in our markets, to others who have been much, much more conservative and concerned and skeptical, and everything in between. So, regulators are people too, as I always like to say. These are public servants. Generally, they're not compensated at the highest levels as you would be in private practice, and they're there for a reason, because they believe in finding ways to protect markets, protect individual investors, and support capital formation. And I think we owe a great deal of deference to the divergent views amongst regulators in trying to figure this all out. Those of us who are in the private sector struggle to figure out what's going on, and we're knee deep in it, and we have the benefit of having very candid conversations with founders and technologists and others. You have to remember that for regulators, gathering information can be, difficult in some ways. They can read CoinDesk same way we do, but they don't have that kind of access. And when people speak to regulators, it's with a very, a clear agenda, and they know that too. So gathering information is difficult. I think regulators want to figure this out, but it's not easy. And decentralized finance is a great example of that. To date, we have not seen enforcement activity really to speak of, at least on either the securities law side or and mostly, again, with some limited exceptions, on the commodities side, or the regulatory BSA side, in the area of decentralized finance. That doesn't mean that they're not regulators across the spectrum are not looking at this closely. DeFi is a mutation of ICOs in many ways. Many DeFi protocols, consciously or otherwise, have learned from ICOs, rather than raising money first and then attempting to build it later, as you said, and maybe not always succeeding. In many cases, the DeFi protocols built first and then issued tokens or raised capital second. And the diffuse way in which capital has been raised does make it more difficult for regulators to assign responsibility when you have, three founders who've raised $40 million and it's in a bank account or, on a wallet somewhere if it's digital, right? It's very easy to assign responsibility. Oh, it was Jane and Sam and Barbara, and it was you guys, you raised the money, you have the money, and, you're responsible for what comes next. With a DeFi protocol, it's not nearly as clear. There may be a couple of core developers, but there may be a whole group of transient developers who are also involved from time to time. They may be compensated in a range of different ways. They may be located in a diverse group of jurisdictions, and they may not have any formal legal construct around them. And that creates, some practical issues for regulators into, if we want to attach responsibility, how do we do that, and to whom do we do it? Do we have the jurisdiction to do that? And I think regulators are being appropriately cautious in approaching this and trying to sort of figure things out.
I will say, I come out of brokerage and banking from many years ago, and the tone and tempo of conversations with regulators is much different than it was 10, 20 years ago. And I would argue that regulators are fairly open to at least the dialogue. And we talk about FinHub and all of that stuff, but there's rarely been a case where a regulator has told you or I, get out, we don't want to talk about this. They're at least trying to keep up, which in my mind is a shift compared to what it was, call it 2008, for example. So I want to get a little granular here, and we talked about this in prep. I want to push on the DeFi thing a little bit. So for the non-lawyers, the thing that always, and I won't bring up Howie broadly, but the thing that always trips up the non-lawyers, the technologists, the company founders is, particularly vis-a-vis DeFi, this idea of common enterprise.
Mm-hmm.
We added a little bit about earlier. Talk a little bit about what that common enterprise means from the original intent, and how that might morph or evolve over time, and what your perspectives are on that.
Yeah, so as you rightly say, Ron, and just to frame up common enterprise, as you said, we one of the elements of something being a security, of course, is the very amorphous concept of an investment contract. And as I think most folks know at this point, the Supreme Court set out a four-part test, which indeed includes common enterprise as one of the prongs, to help later courts determine when a particular arrangement is or is not a investment contract, because unlike a stock or a bond, an investment contract doesn't come with a neat little label. Hey, I'm an investment contract. So it's difficult, and it's a very kind of soft sort of decision that has to be made, was when to impose this standard, and which has significant consequences. The three other prongs of Howey, in some ways, are relatively easier to apply and have generally been applied. So there's almost always an investment of money, because if money's, something is happening, somebody's giving someone else money, that's almost always present. And there's also frequently expectation of profit, primarily from others' efforts, whether it's the developers or the team, whoever gave the money generally isn't doing the stuff. If Ron, you and I go into a joint venture to start up a new media firm, and the two of us are contributing our efforts, that's generally speaking not a security, that's a partnership or a joint venture. But if I, give you a bunch of money, I just won the lottery, and here's $5 million, Ron, go build it, that indeed, that arrangement, almost certainly will be a security. What's important, in addition to those factors, is that we have a common enterprise between us. And courts have really been split as to what that even means. And the SEC has generally chosen to almost ignore this concept of you and I being in a common enterprise. Where this really manifests itself in DeFi is the question of what is the locus? Where is that investment contract or scheme to be found? And when you and I engage with each other in some way, we are in a common enterprise, either in common enterprise has three variants: horizontal common enterprise, whereas there are a group of investors whose money is raised, and we're all in a similar situation. Token holders fall naturally into such a category, and our economic exposure is more or less the same. If I hold a token, and my friend Jane holds a token, and Sarah holds a token, and Bob holds a token, and they're all fungible with each other, then we have horizontal commonality. We're all in this together. Our interests rise and fall. Vertical commonality is sometimes applied, which has to do with me as an investor on the one hand, and you as a promoter. In vertical commonality, it could be very narrow, in which case you and I have to both have an economic interest in the outcome, et cetera. So you've got to have a gain, and I have to have a gain. We both have to be benefiting in some direct sort of way. Or it could be a broader sense, where even if you don't have a direct gain, I'm still relying on you, and we have a horizontal relationship. That complex fact pattern, unfortunately, does not map well onto digital assets. If we are in direct contact, or in law, of course, we say privity, we can find whether or not, and a court can try and decide whether you and I have in some way or another created a common enterprise of one type or another. But if all I did was acquire a token, a digital asset that has no terms, that simply allows me to send an instruction to a network of computers, if all I have is a token, and after I have it, I transfer that token to somebody else, how does owning an asset of any type, token or otherwise, put the asset owner into a common enterprise of any of those three types I just described with that sponsor? It doesn't really do it. They have no rights. They're not recognized. You don't know who they are. That, I think, is really a question still to be resolved. And the SEC has maintained that these digital assets are themselves securities until not the common enterprise goes away. They don't talk about that, but rather until the network is sufficiently decentralized, or you're not relying on the efforts of others. I think it would be interesting to delve more deeply into the question of common enterprise and how common enterprise applies to that analysis. That's probably a much more detailed answer.
That was amazing, Lewis, because it raises a conversation I remember you and I had in one of our legal working group meetings, several of us, probably 3 years ago, because that phrase appropriately decentralized would pop up. as an old product guy back in the day, I would always ask, what do you mean by appropriately decentralized? How do you define that? And it's still, given the work that they were doing, the regulators are really trying to keep up, but it's still not clear when we say appropriately
Yeah,
decentralized.
absolutely right. And I think Ronnie make a great point. One of the problems of bringing new concepts into the law is that we don't have any case law to interpret it, what we call jurisprudence. There are no, prior to the birth of digital assets, there are no cases to turn to say what is appropriately or sufficiently decentralized. And so, by a regulator bringing a new concept into the dialogue, we don't really, as lawyers, have a good basis. Well, we don't have a Howie of sufficiently decentralized, as it were, right? So that may be seen. There, of course, are a couple of cases, most notably the SEC's action against Ripple Labs, that perhaps may generate some new law on this, but to date, it's pretty sparse.
Yep. And from the perspective of updating viewers who may not know, if I understand correctly, there's been a motion to dismiss submitted in the Ripple case. Neither of us is involved, but I think that's where it stands right now, at least
Yeah, I
today.
don't think we've seen the full motion. We've seen their letters have been
Right.
addressed to the court, but we have not seen the full motions to dismiss yet. But that's our sending. That's more or less where we are, and that will turn really on whether there are questions of fact or not that need to proceed, or whether the court is in a position based on the agreed facts to reach a decision.
Got it. I want to, and we're running towards the end. I want to pivot to something that we didn't chat about, but I think I would love your advice on. There are so many students in law school now. We are very privileged in the WSBA to have many as associates, many as research associates as well. And the question we often get is, as a lawyer, how do we get involved? How do we prepare our careers for engagement in this? You've got a great history, and you're deeply involved in this space. If you could talk to law students today, and I'm sure you do on a regular basis, what's your thoughts on the best way to get involved in this and participate as this ecosystem evolves?
That's a great question, Ron. It's such an exciting area, and to be a law student or someone just starting out on your legal career, there's so much going on. I think I'll talk more specifically about the technology, but I think the most important thing I want to emphasize to law students or younger lawyers is to be the best lawyer you can be. That's so much more important, than anything else. I think sometimes that gets a little bit lost in, oh, I have a passion for blockchain or digital assets or crypto, and wonderful. But it's important that you learn lawyering and you develop your skills as a lawyer. And it doesn't really matter that much how you do that. You could be a litigator, you could be a real estate lawyer, you could do all kinds of things, but you want to be the best lawyer you can be. And that should never be overlooked in your interest, for technology, because at the end of the day, that's, as lawyers, as professionals, that's what we're judged on: our ability to understand the law, apply the law, and advise clients as to how the law, may impact them. So that said, there is probably still more smoke than fire in the actual, legal industry in terms of blockchain. There's a lot of talk. There's not a lot of action, and I'm still not seeing a tremendous amount of hiring for, okay, we need to hire 3 blockchain lawyers right now, kind of thing. So I think the second thing I would say to younger folks is be patient. I think this will develop, but don't worry too much if your first job or your current job is not in the blockchain space. Be ready to play the long game. And I think the third thing I would say is, unlike some other areas, a deep understanding and knowledge of the technology itself is critically important. So I would say you don't have to be a coder necessarily, but you should understand code. You don't have to be a DeFi degen, but it doesn't hurt to engage with these protocols. The better you understand them and the more engaged you are, the better, a lawyer you'll be and the better advice you can be. And I guess a corollary to that is there's nothing that stops even the junior-most lawyers of getting engaged in the discussion. Crypto is very much about a community. There's obviously a very vibrant community of crypto Twitter, on Twitter, increasingly on Clubhouse. If you can get into Clubhouse, there's great discussions there, and in a number of other forums. Even on LinkedIn, there's a fair amount of good content. And I would suggest to everyone, when you feel comfortable, leap into that dialogue, make an observation or ask a question. And I think those will those steps will stand people in good stead.
Louis, those are great points, and I know you're very prevalent on social media, and it's always great reading you. And I know you're deeply involved in Clubhouse. We're actually kicking off the week in blockchain every Friday on Clubhouse. Hopefully, we can get you on the guest there as well. Louis, you're a friend, you're a colleague. I learn something from you every time I'm in a meeting with you, and this is our third meeting together today. And it's just a privilege to have you part of this. So I just want to thank you so much.
Well, thank you, Ron. It's a pleasure being here. And again, if you don't know the WSBA or you haven't, gotten involved, this is a great opportunity to do that. And I know, Ron, you've got an amazing team. Just reach out to any of them, and take care, everyone.
Thank you, my friend.